Good morning, everyone. Thank you for joining us this morning. In a few slides' time, I'm going to explain to you why it's difficult to say sorry. But for the time being, I'm going to pluck up the courage and I'm going to say sorry. And the reason I'm going to say sorry is diversity and inclusion is such a broad topic that it's impossible for us to cover every element that we might want to cover within an hour on what might be on people's agendas for 2024. So if you pop to the next slide, please, Tom. What we've done is we've tried to concentrate on the areas that we think will be of most interest and focus in on these particular areas. But apologies if we aren't covering everything, but it's impossible to cover everything in the diversity and inclusion landscape. So I'm going to look first of all at the duty to prevent sexual harassment in the workplace that is due to come into force this autumn. My colleague Fiona is going to look at the new section 19A of the Equality Act and the different types of indirect discrimination claims that might lead to. And then Toby's going to look at equality impact assessments and in the public and private sector, and some thoughts on potential future developments. So if you could pop along a couple of slides, please, Tom. Okay, so mandatory duty to take reasonable steps to prevent sexual harassment in the workplace. Why do we need this duty? Well, a few stats just to get us going. 2021 survey by the Fawcett Society indicated that 40% of women experience sexual harassment during the course of their career. TUC survey in 2023 said 62% of women aged 18 to 34 said they experienced sexual harassment, bullying, or verbal abuse at work. I am conscious, of course, that sexual harassment can work both ways. It isn't all with men harassing females, but those are the majority of the reported cases we have, and those are fairly stark statistics. The most stark statistic, I think, is the 70% one, again from a TUC survey done last year, that 70% of women who experienced sexual harassment in the workplace did not report it. And if it's not being reported, then it's difficult to deal with and difficult to address the causes and to prevent it. So following the Me Too movement, 2017 onwards, there was growing pressure on the government to do something about this issue and the issue of sexual harassment in the workplace. And there was a recommendation that they introduce a duty for employers to take steps to prevent sexual harassment in the workplace. So that's where we are, and that's why we have the duty. If you could pop onto the next slide, please. In terms of the legal issues and the strict duty, a couple of points to mention. The first is the duty is scheduled to come into force on the 26th of October of this year. It is a duty to take reasonable steps to prevent sexual harassment in the workplace. And there's a couple of interesting points there about not so much what it does require employers to do, but what it doesn't require employers to do. The first is that the wording of the legislation is diluted from the original proposals, because the original proposals were a duty to take all reasonable steps to prevent sexual harassment in the workplace. That is now a duty to take reasonable steps. We don't know exactly what those reasonable steps are, which I'll touch on in a minute, but there's a slight dilution in that duty. The second issue to mention in terms of what it doesn't do is it doesn't address the issue of harassment by third parties. Again, one of the proposals and recommendations many years ago, 2019, 2020, was that the government ought to reintroduce the provision within the Equality Act under which employers have a duty to prevent employees and are liable for employees being harassed by third parties at work, so by customers. That hasn't happened. So that isn't covered by the duty. And the third thing to mention that isn't covered by the duty is that the duty, this positive duty to take reasonable steps to prevent sexual harassment, only applies to sexual harassment. It doesn't apply to other forms of discriminatory harassment at the moment. It may do in the future, but at the moment it doesn't. We're just dealing with sexual harassment. In terms of what reasonable steps are, the legislation doesn't set those out. And the intention was that the Equality and Human Rights Commission would update their technical guidance, effectively set out a code of practice telling employers what they needed to do in order to fulfill this duty. And what they've said recently was they anticipated a 6-week consultation process about updated guidance to be launched in the summer of 2024, and the final version of the guidance, therefore, to be published by September 2024. What we've not seen yet is we've not seen the start of that consultation process. And it strikes me that September 2024 is cutting it fairly fine in terms of telling employers exactly what they need to do. We've got a fairly good feel for the sorts of things that we think will be in there from current guidance, but nevertheless, it does seem as though they're going to be cutting it a bit fine. We were hoping that when we scheduled this webinar way back in January, February, that by now we would have a bit more detail. We don't have that detail, but we are able to offer substantial guidance on what we think will be in there and what we think employers will need to do to discharge their duty. The other thing to mention here is what are the remedies? How does this duty bind? What happens if an employer fails in its duty and doesn't take reasonable steps to prevent sexual harassment in the workplace? And the first point to mention here is there is no individual standalone claim against an employer by an employee for a failure to carry out this duty. So if I'm an employee and I'm at work next year or this year, October, November, December, my employer does nothing, doesn't issue a policy, doesn't carry out any training, appears to be doing nothing to prevent sexual harassment in the workplace, I don't have a right to bring a claim to the Employment Tribunal and say, my employer is doing nothing to prevent sexual harassment happening in my workplace. Where the law bites is in two respects. One is, if I am sexually harassed and I bring a claim and I'm successful in that claim, then the tribunal can increase my compensation by up to 25%. So there is a higher level of exposure to the employer. The other is the EHRC are able to enforce the duty. So they are the body that can take steps to investigate employers, to make recommendations, to enter into legally binding agreements with employers in order to enforce this duty. You'll have seen recently there have been a number of high-profile cases where the EHRC have got involved in large employers and have got them to enter into legally binding obligations with them and an agreement saying, you're not up to standard, you're not doing what needs to be done to prevent discrimination in your workplace. These are the steps you've agreed to take in order to remedy that. So those are the two respects in which the duty will be implemented and enforced. If you could pop onto the next slide, please, Tom. So what will reasonable steps be? As I mentioned, it would be nice if we had a simple list, wouldn't it, from the EHRC saying, these are the reasonable steps you need to take, steps 1 to 10, you do them and you discharge your duty. Even when we get the updated guidance, technical guidance and a code of practice, it's not necessarily going to be that straightforward, I don't think. But these are the sorts of things, and I'll go into these in more details, that we're talking about. So having a policy in place, having training program in place, reporting mechanisms, monitoring, risk assessment, and workplace champions. And I'll go into these in a bit more detail now. So if you pop to the next slide, please, Tom. Okay. So the bad news in this area is that it appears that training does not work to prevent sexual harassment. I mentioned at the outset, 40% of women reported experiencing sexual harassment at work. That figure has remained fairly constant since the 1980s. When studies were done at that stage, it was at the same level. Since then, you'd have thought that we are a more enlightened work population, and that B, we are a work population who have undergone training about equal opportunities, discrimination, harassment, sexual harassment. But that doesn't appear to have improved the statistics at all. It hasn't reduced the amount of sexual harassment in the workplace. And there was one study I saw done at Harvard University suggesting this cycle as a potential reason as to why training is not only ineffective in reducing sexual harassment in the workplace, but might actually be enabling it to a certain extent. And the theory in this study was that what we do is we make training mandatory on preventing sexual harassment. The subconscious message that men receive, and again, I'm conscious sexual harassment can work both ways, but the majority of reported cases are men harassing women. The subconscious message men receive is that they need fixing. They are being required to attend this training because they are bad and need fixing. In response to which they get defensive about the issue, and being defensive about the issue, they are more likely to blame victims or, and this is probably the more likely scenario, to disbelieve claims. So when complaints are raised by women, and when those complaints are being judged as grievances or harassment complaints by men, they are, as a result of the training they've received and these subconscious attitudes, not deliberately, but just subconsciously less likely to believe women, therefore less likely to uphold complaints. And therefore you get to this position where 70% of people who experience sexual harassment at work don't complain about it. So they don't get dealt with, they don't get remedies, and you end up in this cycle. Now, I'm not saying that study is necessarily 100% correct, but it's a fairly authoritative study and is reflected in the figures and the fact that current sexual harassment training we have doesn't seem to work. So what's the solution? And what's the solution to that? And how can we help with that situation? So if you could pop to the next slide, please, Tom. How do we help training to work? And to break that cycle at source and to prevent the defensive attitude towards sexual harassment, then we think that what training needs to do is to embed a positive culture. And certainly for the in-person training that we now deliver to clients, we've moved these elements that were historically a bit of an afterthought after setting out the legal definitions and all that sort of stuff. We've moved them to the front and center of the training, which is role modeling, allyship, and bystander intervention. Role modeling in the sense of having good examples at leadership level, and that could be work champions, it could be visible participation in events or visible supportive initiatives. Allyship, and this applies to all elements of discrimination, not just sexual harassment, but in this context, the driver is to prevent a sort of negative hands-off attitude towards sexual harassment and move towards being an ally. And the third element, and a really important element, is this issue of bystander intervention as a way of trying to address the underreporting problem. Now, if people aren't reporting issues, that might be because they're concerned that they won't be believed, or that it might affect their career, or that it won't change anything. But in a workplace culture where others act as bystanders and call out harassment when it occurs, then that encourages complaints and helps embed a culture in which raising complaints is not viewed negatively. Now, that's easy to say, of course, about being a bystander, but this sort of training can help people because you can help give people the skills on how to be an effective bystander and how to call out poor behavior in the workplace. There are different ways of doing that and different ways of doing it in different situations with different people. And so giving people the skill set as part of that training, rather than just saying to people, don't sexually harass, giving the people the skill set to be a good bystander might help the training be more effective. The second element of the training that I think is really interesting is training people in how to respond when complaints are made about their behavior. And sometimes those complaints will be about explicit acts of sexual harassment, but there will also be complaints made about microaggressions that a manager or a colleague doesn't necessarily realize that they're doing. And there is a school of thought that again says that training people in their initial response to those complaints and getting away from that initial very defensive response can help resolve these situations. The other thing some businesses are finding useful is training where an element of honesty is required and training in things like unconscious bias. There's been a number of studies done that people don't necessarily realize the biases they hold and the way they are behaving. And so all of that training or all of those issues, I think, should ideally be worked into a training program dealing with these issues. Next slide, please. Okay. Reporting mechanisms. And a challenge here for businesses, we talk about, as part of reasonable steps, we talk about having a policy in place, having training in place, and having a reporting mechanism. We expect that to be included in the updated guidance when it comes through. And the challenge to businesses that I see here is one of saying to businesses, well, are your reporting mechanisms fit for purpose? Given those statistics about the underreporting issue, and to have us think about things like, are people trained in dealing with complaints of sexual harassment? They are a difficult type of complaint to deal with, particularly when you have conflicting evidence and two people giving different accounts for which there are no independent witnesses. They're difficult areas to deal with. Are people trained in dealing with complaints of sexual harassment? Are they trained in dealing with grievances generally? But also, do you offer specific training on these areas? Do you just use the grievance procedure, or is there a separate procedure? A number of employees now have a separate bullying and harassment procedure and complaint procedure to the usual grievance process. Is there support offered for those against whom complaints are made? Now, this isn't to say that complaints are disbelieved, but there ought to be an acknowledgement within a business that if we are to move forward and help resolve these issues, there's a concern from people sometimes when complaints are made against them, they feel that they are left out to dry. And does your reporting mechanism, does it offer support to both the person raising a complaint and the person alleged to have sexually harassed? Does the process seek a resolution? There's a big debate generally about grievance processes and how effective they are in managing disputes in the workplace, because we do see them as that. We do see them as a dispute, and we do see the grievance officer as a judge to come up with a decision as to, well, do I uphold your complaint or not? Does that help resolve the issue? Are there other ways in which issues might be resolved? And finally, and I'll touch on this when we talk about monitoring, but are complaints of harassment upheld? Do you have records of whether complaints are upheld? And in terms of upholding that complaint, as I mentioned at the outset, it's very difficult generally to say sorry. My experience within the employment context is that employers dealing with complaints of sexual harassment, employers naturally, I think, find it very difficult, one, to uphold complaints and say there has been wrongdoing here, and two, to say sorry for that. Because there is a concern that if I do that, that's acknowledging something unlawful has happened. It's opening the door to a complaint being made. It's opening the business up to exposure. So only where there is really clear evidence of sexual harassment will I uphold the complaint, and will I say sorry and apologise. And again, I just challenge businesses to sense check that and have a think about their approach and whether their approach is a meaningful one dealing with complaints, and therefore encouraging complaints if wrongdoing does happen, because we can then deal with the issues and we can manage and improve the culture within the workplace. Next slide, please, Tom. The final thing that we've seen mentioned a couple of times, and I think may well be in the updated guidance when it's released, is encouraging employers to take a risk assessment approach to sexual harassment. We looked at the statistics at the start. If there was a 40% chance that an employee would suffer a particular sort of accident at work during their career, that would be a huge red flag on a health and safety risk assessment, and significant mitigating measures would be taken. There's a 40% chance someone was going to suffer a particular accident at work. So if there's a 40% chance someone's going to experience sexual harassment at work, then there's an argument that there should be a similar risk assessment approach taken. It causes damage to the individual, it can cause damage to their health, it causes damage to the business. It is a risk. How do we mitigate that risk? And how do we assess that risk? And challenging businesses to look at a few things. So where are the higher risk areas? There are some industries in which the risk of sexual harassment is higher than in others. Particularly the risk of sexual harassment by third parties, which, whilst, as I say, the employer doesn't at the moment have a legal duty to prevent, the reality is you would want to prevent that for your workforce. So where are your areas of risk? Statistics show that individuals who work irregular hours, so casual workers, 0 hours workers, are at greater risk of sexual harassment in the workplace. And the statistics also show that claims tend to arise where there's an imbalance of power. So you do have areas of higher risk than others. And so the challenge would be, what is the business doing? Where's its risk assessment on sexual harassment in the same way as it is on health and safety? That, I think, will, or is likely to form part of a duty to take reasonable steps to prevent sexual harassment, is to carry out a risk assessment process. And then similarly, and finally on this area, the issue of monitoring. Again, if you had a health and safety risk, there would be an ongoing assessment process and you'd be monitoring progress on there. And similarly here, there will be a challenge, I think, to business to say, well, look, where is your record of monitoring the complaints received and the outcomes of those complaints? How many have been upheld? In what areas? Are there pockets of business where you're getting more complaints than other areas? What are you doing to address those situations? There's also a suggestion that you may carry out staff surveys, and anonymous staff surveys, to get a feel for where the pockets of risk are. So I do think that when we have this duty in force in October, there's an inclination perhaps to think, well, we'll just put a training program in place and we'll just get people to carry out training. And I'm not sure that will be enough in terms of taking reasonable steps. The training will be a really important element of it, but all of these other elements, risk assessment, monitoring, I think, will be important to show that if you are challenged as a business, for example, by the EHRC, what steps have you been taken? You can say, well, not only have we got a policy in place, not only have we got a robust training program that is effective and that we monitor its effectiveness, we have good complaint mechanisms in place, again, which we've stress tested, which we've improved, which we've modified, and which we can show statistics as a result of that. So that's where I think employers will want to be getting to in terms of their duty to take reasonable steps to prevent sexual harassment in the workplace. If you've got any questions on that area, as Tom said, pop them in the Q&A function and we'll try and pick them up at the end. I'm now going to ask Fiona to talk about this section 19A, indirect discrimination duty.
Thanks, Matt. Good morning, everyone. I'm going to talk about indirect sex discrimination and the changes that we've seen in relation to section 19. And you'll all be aware of indirect discrimination, where there is a policy or of some sort that applies. It may not overtly appear to discriminate, but actually it does indirectly discriminate against one particular group. And there have been changes with effect from the 1st of January this year. There's a new section in the Equality Act which is designed to reflect EU case law now that we've left the EU, and effectively to grant the same level of protection against indirect discrimination as those in the EU. Now, prior to this, I think it was generally considered that if you were going to bring a claim of indirect discrimination, you had to possess the relevant protected characteristic. And I think the typical example of indirect discrimination, which we would all think of and which we probably most commonly see, is issues arising from flexible working requests because of the requirement to work full time. Now, the requirement to work full time, that is this, what's known as a PCP, a provision, criteria, or practice. It's something that we have in place in the workplace, which has a disproportionately disadvantageous impact on women because fewer women than men can work full time due to childcare responsibilities. So on the face of it, full-time work is indirectly discriminatory and that provision needs to be justified. So as I said, we will often see flexible working requests made in the workplace. They may well be for childcare reasons, and we will often advise an employer in relation to that. If the employer doesn't feel that they can accommodate it and they are concerned about that issue being raised, well, can we justify it? There are other types of examples as well. So it might be requiring a new recruit to be a graduate. That could disadvantage older people who are less likely to go to university. It could be certain dress code requirements that may impact on people for religious reasons. So, the key is with indirect discrimination, or as it was that we very much thought, in order to bring a claim, you had to be part of that group that was subject to the disadvantage. Now, there was a case in Bulgaria which has changed this. Now, it doesn't relate to employment as such, it relates to services, but that ultimately relays into the wider legislation, and it's certainly something that has been brought in now into our legislation as a result of this EU case. Now, this Bulgarian case, which I'm not even going to attempt to pronounce, but that it's referred to as Shez, a woman lived in an area of her town that had a significant Roma population. She was not of Roma origin, and the authorities in that region decided to position electricity meters at a greater height because of concerns about Roma families tampering with them. And as a result, this individual, who was not of Roma origin, couldn't see her meter and check her bills, and she suspected they weren't correct and wanted to be able to check them. So she raised a claim of indirect discrimination because something was being applied. But up until that point, our understanding of indirect discrimination would be that, well, because she's not of Roma origin, she would not be able to bring a claim of indirect discrimination. She's not part of the discriminated group. And we thought you had to be part of that disadvantaged group to bring the claim. And the ECJ decided that wasn't the case, and that she could in fact bring a claim. So that's why we now have these changes to indirect discrimination, because it means that not only those within the disadvantaged group, if, for example, you take the example of a flexible working request and it's a female, it could also apply to others who are not within that disadvantaged group, but who are not within the protected characteristic, but are disadvantaged by it. And we've got the definition on the slide there. So now claims can be brought where an employer, for example, applies a provision, criteria, or practice. That provision, criteria, or practice applies to people who have the protected characteristic, i.e. women and those who do not. B does not share the protected characteristic, and the provision, criteria, or practice places people with the protected characteristic at a particular disadvantage. B, who's not in that protected group, is placed at the same disadvantage, and the provision, criteria, or practice is not a proportionate means of achieving a legitimate aim. The implications of this now for you as employers are, when you're introducing a new policy or benefit, at the moment, you may well be analysing the risk of indirect discrimination claims coming from a certain category of employees. But now you also need to consider the risk of claims from others who might suffer the same disadvantage, even though they're not in that protected group. And the most the example that springs to mind, of course, is a man with primary child caring responsibilities who's placed at a disadvantage by his employer's requirement to work full time or requirement to work in the office. That man could now bring an indirect discrimination claim on the basis that that criteria puts women at a disadvantage and is therefore discriminatory, and he suffers the same disadvantage. So I think that would be the key area for me that we see as a result of this going forward, and something to be wary of, but it could reach out into other areas too. And that was all I was going to mention on indirect discrimination. So I'm going to hand over to Toby.
Thanks so much, Fiona. It's literally like we planned this, Beverly. My section of the talk feeds on so well from what Fiona just talked about. I think the information that comes from the new duty under Section 19 it is so complex to try and get your head around. So we look a bit more about, say, business protections, right? How can a business react to that change in the law? What can it do in order to protect itself from discrimination complaints? So I'm going to talk a bit more about equality impact assessment. So equality impact assessment is, as it sounds, you're assessing the impact on equality of a certain aspect of your business, so something that a business does. So it's an evidence-based approach. It's designed to help you look at your policies, practices, events, decision-making, whatever it might be, and look at issues that form from that. Are there barriers that we're going to put in place to participation from a certain group of people, or is that going to cause some sort of disadvantage? If it is going to come some sort of disadvantage, is that justified? I.e., do we have a reasonable decision-making profile here? Have we got a legitimate aim that we're trying to focus on to make sure that the policies that we're going to use are beneficial for the business but don't impact on people too much? So equality impact assessment itself is designed in order for a business to look at those processes, look at those policies, and write that down to document their decision-making. If you're in the public sector, you've probably already heard of these. The public sector equality duty requires a public sector organisation to undertake formal equality impact assessments. But if you're in the private sector, there's no specific obligation on you to take that step, to undertake an equality impact assessment, but you do have an obligation to avoid discrimination. Now, the Equality Act's really clear. You must not discriminate. That's throughout the Equality Act itself. That's the test that's set out there. A business must not discriminate in the way it treats its employees. So you have to, as employers, organise your operations in order to avoid discrimination. Now, Where I've seen equality impact assessments be of particular use is in the two examples I've got on the slide there. So the most common one that I've seen is redundancies. So it's become, well, as far as I'm concerned, it's become a common practice for claimant solicitors who are going through representing a individual going through a redundancy process to write to the employer throughout the redundancy process itself and saying, well, where's your proof that you've assessed the impact on equality of this process? Where's your proof that before you entered into this redundancy procedure, for example, you looked at what the impact of that process might be on people with particular protected characteristics? And if as an employer, you haven't done that, what you're going to have to respond back to that claimant solicitor is to say, well, we have given our mind to it. We don't believe that there's going to be any particular issue. But if you've got an equality impact assessment, you can produce that to them. And you say, look, we take our obligations towards equality really seriously. We've produced an equality impact assessment. There was a requirement on us to do so, but we've done it. Here it is. And A, it's beneficial to the business because you avoid discriminatory practices and you put your mind to issues that might come about. And B, it helps you defend claims. And the earlier you can defend that claim, the less likely an employee is to feel mistreated and the less likely they are to bring a claim in the future. So look, the specific examples we've got there, redundancies, changes in terms of benefits. Yeah, is a change to a term and a benefit of someone's contract of employment, is that going to adversely impact on them? Do they have a particular characteristic? Or if it's a wider change, is it going to impact on the group? How do we mitigate that impact? Do we think it has a disproportionate effect on a certain group of people? Another example that I just thought of as Fiona was talking is, of course, recruitment. You know, if we are assessing a job, we're posting a job online, we're saying, look, why are these terms full-time? Why do we need a certain qualification? Is that justifiable? Are we able to say why we needed it to work in this way? Because if you're posting a job advert, you're going to get people who apply, they're asking for flexible working, etc. If you have an equality impact assessment, you say, well, actually, look, we've assessed this role, we've assessed what we need, and we believe this is justified, even though it is full-time, and you can produce the quality impact assessment to back yourself up, you put yourself in the best possible position. An EIA is just going to help you to secure that, but it also helps put managers' minds towards why they're making the decision that they are. We put the burden of proof and discrimination claims on the slide there. And look, in a claim in an employment tribunal, if a claimant proves facts from which, in the absence of an explanation, discrimination could be inferred, the burden of proof to disprove that argument as being discriminatory transfers to the employer. So you've got to explain the steps that you've taken. It's a darn sight easy to do that if you've got a document that says that you've done it contemporaneously at the time. You've worked out what the process was, you've worked out what the impact was, you've sought to mitigate it, and you said, actually, we don't think it's discriminatory at all. It just sets you in completely good stead for having that work forwards for you. What I'd suggest is for the processes and procedures that any of you are going through with your employees, consider having EIAs as part of your process as a matter of course. You've got a pro forma template, assesses the risks, gets signed off by a manager at the start of the process before you move forward. It just puts you in best stead. So just quickly move on to the next slide, please. So I get to look now at diversity, inclusion, and sort of future developments as well. We're not going to be political here, but we are only covering the Labour Party's proposals. The reason for this is the Conservatives haven't announced any significant employment law reform, and we don't really have time to go through all of them in detail from the other parties as well. So the Labour Party have said that they're going to introduce quite a lot of new employment laws. It might be that all of these go through, it might be that just some of these go through, time will tell. But the ones we've got at the moment, they want to focus on specifically for D&I. So in pregnancy cases, they're going to make it unlawful to dismiss a pregnant individual up to the point of 6 months from when they return from maternity leave. So that extends the period of protection past the period of time when they're on maternity leave to 6 months after they return as well. And it says save in specific circumstances. Now, we don't know what those specific circumstances are just yet, but there are likely to be some level of exclusions that come from that. They also going to introduce a law that requires larger employers to produce menopause plans. Okay, yes, you're going to have a documented plan in place. They're going to introduce mandatory ethnicity and disability pay gap reporting for those employers with more than 250 employees. So it's going to mirror current gender pay gap reporting rules. There's going to be a requirement for larger employers, no definition of larger yet. I would assume 250 plus, but we'll have to wait and see. So there's going to be a requirement for larger employers to publish an action plan about what they're going to do to close their pay gap. That's already good practice. You do your gender pay gap reporting. You've got to say what you're going to do with it. You're going to talk to your employees about it, talk to potentially your customers as well, and say this is what steps we're going to take. Having that in place already is probably good practice, but what Labour have said is that they'll make that a requirement. And this is an interesting one, this next one. So they are going to look at extending the time limits in employment tribunal claims. So it's currently, on the whole, 3 months from any cause of action. The proposal is to extend that to be 6 months from any cause of action. Now, that's based on the recommendation that 3 months was too short a period of time for discrimination complaints, such as harassment, where genuine claims just simply weren't being raised within that period of time. So with ACAS early conciliation still being in place, it could be that businesses go from a 3-month limitation period plus any extension of time through ACAS early conciliation to now a 6-month limitation period plus any length of time through early conciliation. So it could extend it between sort of 6-8 months time with your risk profile before a claim might be brought. So definitely one to watch out for. And they're going to look at the public sector duty being extended to considering socio-economic disadvantage. So that is actually already in the Equality Act, but it's never actually been enacted. So it's just extending that out for public sector. There are probably, and I say probably because we don't know when they're going to come in, there are probably going to be some changes to non-disclosure agreements as well, to NDAs. So NDAs are already prohibited in higher education. That's following recent legislation, but there has been a consultation about their use in general. So in July of 2019, there was a consultation on NDAs, and the government committed to legislate, quote, when parliamentary time allows. So we've no idea when this might come in, but the proposals are that they are going to introduce legislation for these specific issues. So what they're going to be saying is that there's going to be no confidentiality provisions in an employment contract or in a settlement agreement that could prevent an employee from making a disclosure to the police, to regulated health and care professionals, or legal professionals. So within there, you might have seen from explicit use, obviously we use Freeth, we've already done this. Within the confidentiality provisions that we include, these are already expressly excluded from the way in which that confidentiality would bite. Now, there's already guidance that solicitors should be following, but there isn't legislation currently to back that up. This is just going to be the turning of the tide. So, of course, individuals should be able to report criminal behaviour to the police. Of course, they should be able to seek health and social care advice from a regulated care provider. Of course, they should be able to seek legal advice. All those things make complete sense, but the use of NDAs in the past has been really, really brutal. And there's been instances that we've seen where the terms of them have been so unnecessarily restrictive as to cause people harm. This is what they're trying to address that balance. The confidentiality clauses, so this is part of the new legislation, are going to need to clearly set out their limitations. So limitations on confidentiality in an employment contract will have to become part of the mandatory written statement of employment particulars that is provided to an employee. That's probably going to amend Section 1 of the Employment Rights Act to confirm that if there are to be confidentiality provisions, A, they have to be in your main statement of terms and particulars, and B, they have to expressly say which parts you are still able to breach that clause for, so which parts of confidentiality you aren't restricted from disclosing. There's going to be a new right introduced for an employee to bring a claim for compensation in the employment tribunal, where a confidentiality clause in a written statement does not meet the new drafting requirements. So if you have a confidentiality provision that doesn't meet those requirements, there's going to be a claim that an employee can bring against you. We don't quite have details on that yet. It's probably likely that'll be very similar to the claim for failure to provide written terms of employment, not a standalone claim by itself, just part and parcel of a compensation action and a separate head of damage, but not a claim that could be standalone brought. Confidentiality clauses in settlement agreements that don't follow the legislative requirements will be void in their entirety. Now, that won't void terms of the settlement agreement itself. It won't apply retrospectively, but if you get the drafting wrong in a settlement agreement, then what this new law is going to say is that it will simply just wipe out that provision. There'll be no confidentiality whatsoever, won't be binding, will be completely void, but the remaining terms of it will remain. Now, when the government consulted on this, they declined to provide standard wording for NDAs. in essence, they've kind of left it up to businesses and to turn to their lawyers in order to determine what that wording should be based on the guidance and legislation that's going to be produced. It's fairly common. We tend to see too restrictive a provision on what things should say, as we are allowed to take a commercial decision on how these aspects should be reported. They also looked at whether or not there should be a reporting duty for the use of confidentiality clauses, specifically in discrimination or harassment complaints. Again, they declined to do that, saying that the focus really should be on avoiding discrimination and harassment rather than having a mandatory reporting mechanism when you seek to use a confidentiality provision. Now, as I said before, NDAs are already prohibited in higher education. There have been some recent movements on this. In May 2024, it's been discussed in Parliament again by some MPs who are trying to recognise that individuals who sign a non-disclosure agreement could be classed as victims under the Victims and Prisoners Bill 2022-2023. There's also a Treasury report called Sexism in the City, which follows that the Treasury is saying that they're not going to recommend a whole-scale ban on NDAs, or whole-scale ban on NDAs specifically for harassment cases, but the turning of the tide that we're seeing is that there's going to be a heck of a lot more scrutiny over the use of the NDA itself, the terms of it, how it's drafted and how it's implemented as well. So time does seem to be up on terms of these very broad, very blanket, very onerous terms. So we need to have a lot more thought into what those are going to look like in the future. So if you get it wrong, it's completely void and you get no protection whatsoever. Matt talked before in relation to third-party harassment as well. So the government haven't taken the opportunity to look at third-party harassment right now. So an obligation on an employer to protect an employee from a third party, normally a customer, things like that. It was proposed. It received massive pushback because of the onerous obligations on employers. To protect your employee from anyone and anything that interacts within your business. It could well be that gets dampened down a little bit. I mean, when that was being proposed at the time, it helped a few clients go through customer respect charters. So we had large businesses send a customer respect charter to their customers and say, this is what we expect from you when you deal with our employees, and here's what you can expect from us. That's handy because even though there isn't going to be a duty to prevent third-party harassment, an employee could still claim constructive dismissal if they say, well, look, I'm getting harassed by this customer. You know that they're awful. You keep sending me to them. Whilst you have a duty to protect me, I still want you to do something about it. And if you don't, I'll lose trust and confidence in you. So having the customer respect charter in place has been really useful. It also puts you out there as being kind of a leader to say, well, look, we are seeking to protect our employees. That's all we've got for today in terms of the current slide, but I thought I'd give you a little sneak peek of what our next webinar is going to be about. So we're talking about AI, and this is going to be our next webinar in November. And part of that is going to be looking at the implications of using AI on equality and diversity and inclusion. So, I mean, there are risks in relation to the use of the algorithms. And a real core example of this was a few years ago. A larger employer fed thousands of CVs from successful candidates into an AI system in order to train it as to what a successful candidate might look like. And the idea was that the algorithm would then understand that. It would make shortlisting much more efficient. You just process a CV through it and it kick you out who are the most successful candidates going to be. The algorithm analysed the CVs at this point and deduced that there were more successful male CVs than female CVs. Therefore, it went to a binary level and it said male equals successful. Therefore, when it carried out the shortlisting exercise, it immediately discounted any female employees in that process. So entirely discriminatory, can't be relied upon, but it's that aspect that we're going to be looking a bit more in depth in November, because looking at this, it's so fascinating because you think, well, the risk of using, say, an AI system for recruitment or performance management comes from how do you even defend an employment tribunal claim in that scenario? Because who did the discrimination, for one? Who's giving the evidence about how the discrimination took place? How do we know how the algorithm made its decision? And then we're also considering who's at fault. And I mean, obviously, an equality impact assessment might help you out with that. Say, well, we've run this algorithm to see what the outcome was going to be. We don't think it has a disproportionate impact on equality and diversity and inclusion, but having that documented is going to be really interesting moving forward too. So hopefully we'll see you all there in November as well. So thank you all so much for listening this morning. I think we do have some time for questions, and I've seen a few questions running in on the chat function too.
Yeah, thanks, Toby. So just to pick up some of the one, hopefully easy one for you, Toby. Do you have a template for risk assessment and a template for equality impact assessments?
Yep, sure do. My email's on the bottom there. If you want to drop me a line, we can talk about it.
Okay. And then we've got a few questions around the preventing sexual harassment duty. So I'll pick up some of those. First, a few people asking about the Conservatives suggesting that they leave the European Convention on Human Rights and any impact that might have on this and discrimination generally. I mean, all the stuff we're talking about here is enshrined within the Equality Act 2010 and so will remain the law. The enforcement body is the UK Equality and Human Rights Commission, which is entirely separate from the European Court on Human Rights, even though their monikers are fairly similar. So I don't think, even if we left the European Convention on Human Rights in the short term, anything within the Equality Act 2010 would necessarily change. A couple of other questions on that. You mentioned that third-party harassment has been removed, but as the requirement is to prevent sexual harassment in the workplace, does this inevitably include having to consider third-party harassment in order to discharge this duty? Yes, there is certainly an argument. The legislation simply says employers must take reasonable steps to prevent employees experiencing harassment in the course of their employment, which potentially covers harassment by third parties. So I think it arguably does form part of the duty, forms part of that risk assessment process. In terms of the exposure risk, speaking as a cold-hearted lawyer, what I would say to you is, at the moment, if you don't do that and an individual does suffer harassment from a customer, for example, then, as Toby outlined, there's no claim the individual can bring for discrimination by that customer. Therefore, there's nothing to uplift the award by 25% on. But, as Toby mentioned, there could be constructive dismissal claim risks. There could, in theory, be enforcement by the EHRC, where they say, if we hear constant reports, as they have done with some large employers, constant reports of employees suffering harassment from members of the public, and you aren't doing enough to address it, then that is something that we will seek to implement. So I do think there's an argument that should certainly be covered in risk assessments and monitoring. And I think there's an add-on here saying someone who works in the hospitality industry, they have training in place in terms of risk assessments. What practical steps could they take to mitigate against sexual harassment that they aren't already doing? And I think the example there would be that if you have the risk assessment, you identify, and it does tend to be that hospitality is a big risk area here. You identify the risk. One of the challenges I would put to you if I were on the other side of the equation is, well, can you demonstrate how you've dealt with these issues? If you can show that in the last year you've had 100 complaints from members of staff about members of the public, as a result of which 75 people have been barred from premises, that could well go towards showing that you are taking reasonable steps to prevent sexual harassment in the workplace. Again, your duty isn't to prevent sexual harassment in the workplace. It is to take reasonable steps to prevent it. You aren't required, and you won't be liable for every single incident of harassment that takes place from third parties, but you are required to take those reasonable steps to prevent it happening. What have we got here? We've got someone saying, if training focused less on male perpetrators, do you think this would have a more positive impact? I think there's certainly an argument for that. I mean, I've been very conscious, I've mentioned it a couple of times, that we aren't just talking about male on female sexual harassment. We aren't necessarily just talking about senior male on junior female sexual harassment. And there is a spectrum of it, and raising that issue with people may well mean that people approach the training, particularly men, with a less defensive attitude. Bystander intervention, should that be encouraged in certain situations? It may work well, but may also encourage someone to intervene in a more dangerous setting. Yeah, which is a really good point, and that's why I mentioned in terms of the training and training people on being effective bystanders is part of that. And the training sessions I've done have been setting different scenarios and saying, in this scenario, what would be the appropriate intervention here? And if it's a particularly dangerous setting, the appropriate intervention might not be putting your neck on the line and standing up and saying, hey, don't do that. Your intervention might be reporting it behind the scenes, or it might be talking to the person who's experienced it. So the bystander intervention and what we will call calling out isn't necessarily always standing up and shouting and telling someone to stop. You can intervene in a number of different ways. Let me see if I've got any other questions. We've had that one asked. We had another one about the equality impact assessment template. So I think we've dealt with the question. Yes, so I think we've dealt with the questions there with 4 minutes to spare. So thank you very much, everyone, for attending. As Toby mentioned, we're doing another webinar in November on AI, which will touch on discrimination elements, but also other elements of the adoption of AI, which we see on an exponential scale in the HR framework. So thank you very much, everyone, for attending. Have a good rest of the day.